Guys, this is going to be just a quick video to talk about Amber Heard's appeal. So we've heard her attorney announce that she intends to appeal, and folks have a lot of questions about that process, what it looks like, what might she argue, does she have any chance, all kinds of questions about it. So if you don't know, my full-time practice these days is appeals. I have been doing criminal appeals for over 10 years now, not sure how long altogether, and for the last 5 roughly it's been my full-time gig. So I haven't done trials since I think 2018 or so was my last one. So I know quite a bit about the process. Obviously, different states can have different rules. I'm not super familiar with all of the rules in Virginia, but I am familiar with some of them. So where I am, I'll go ahead and talk about those. And where I'm not, I'll just talk about basically the general process that I expect would follow in that state, like most other states. So first off, how do you start an appeal? So the appeal is initiated by simply filing a notice. Virginia is a state that gives a civil litigant a right to appeal. So it isn't something they have to ask for permission to get. They have a right to do it. Once the judgment is entered, which is the hearing that is set for June the 24th, is for the judge to sign the formal written judgment, then at that point, Amber Heard will have 30 days to file her notice of appeal. That will essentially initiate the process and start the timelines for everything that she has to do to get the Court of Appeals in Virginia to review the case. So yes, it is a separate court. This is not Judge Azcarate doing the review process. The Court of Appeals is a separate court. Typically, appeals are decided by a panel of judges, not a single judge. And because they are reviewing the rulings of the lower court, they are separate independent judges who will be looking at Judge Azcarate's rulings, whichever ones Amber chooses to bring to them as the basis for her appeal. One of the questions that has come up has been about a bond, and does she have to post the entire amount of the judgment in order to appeal? The answer to that is no. There is a Virginia statute that allows her to post the amount of the judgment if she wants to stay Johnny's ability to enforce the judgment until the appeal is decided. But she's not required to do that. The only bond she is required to post is simply the costs of appeal or $500, basically whatever additional amount Judge Azcarate could require, but the default is a $500 cost of appeal bond. So unless she wants Johnny Depp to be foreclosed from doing collection proceedings, which are things like garnishments, there's discovery that can be done in collection to investigate like her bank accounts and her assets, her income sources, things like that. If she wants him to not be able to use those tools until the appeal is resolved, then she has to post the full amount of the bond plus attorney fees plus interest, which is obviously a pretty significant amount of money in this case. So once the appeal is initiated, what are the types of things that she can argue? Well, appeal is typically limited to legal errors, and so this has a couple of important meanings. First off, it's not a process to relitigate the facts. It's not a process to consider new evidence. The Court of Appeals is essentially there to review what happened in the lower court and evaluate whether a mistake was made, and that's really it. So one of the things I know folks have been talking about is a 21-day limit to basically deal with jury issues, that the jurors should potentially not say anything for 21 days because of a type of limitation there. I want to be clear, I'm not entirely sure where the 21 days comes from, where that idea arose. But what I can say is that my understanding is that before the judgment is entered, the parties have the opportunity to ask the judge for a new trial, to suggest that there are reasons for this trial being unfair and therefore the result should be discarded and a new trial should be ordered. And so jury misconduct is a basis for a trial court to grant a new trial. And so what you do is you bring a motion, you present evidence that the jurors have failed to follow the court's instructions in some material respect, and the judge will then rule on that motion, either grant it or deny it. So that issue itself is not something that directly goes to the Court of Appeal, but what happens is they can litigate it in the trial court, and then if the judge rules in a way that they don't agree with, that decision can then be appealed up to the Court of Appeals. So I want to say first off, there is no evidence, certainly in the public record, of any jury misconduct at all that would support this type of argument. There's been basically a suggestion by Elaine on various television shows that sure, the jury couldn't possibly have followed the court's order to avoid social media, and therefore they must have been tainted by it. Obviously, there are some real problems with this line of reasoning, okay? Just because Elaine maybe doesn't respect the court's orders to, you know, hypothetically not discuss the testimony with Amber Heard during the break, when they came back and coordinated a change to her testimony that she had given the week prior. Kind of odd that they were able to do that without discussing her testimony as the judge ordered. But, you know, apart from projection on Elaine's part that apparently nobody takes the court's orders seriously, there's no evidence of any type of wrongdoing on the part of the jury. And there would need to be evidence for that to even be considered. So at this point, haven't seen any type of motion, not really concerned about any basis for it. If they are going to raise it, that will need to be before the judgment is entered, before Judge Azcarate can rule on it, and then only if Judge Azcarate denies it could that potentially be an issue for the Court of Appeals to look at. So because the Court of Appeals is primarily looking at legal errors, they're looking at either interpretations of the law that the judge got wrong and that had an impact on the case, or they're looking at exercises of judicial discretion that were not appropriately exercised. So the difference between these is that certain legal questions, for example, the jurisdictional questions from early in the case, is it even appropriate for Virginia to hear these? That depends on legal standards that are set out in statutes, court rules, and common law, case law, typically. So the Court of Appeals, in looking at a legal error, is basically going to just do it independently. They're going to do their own research into the question of, for example, what is the requirements for a court in Virginia to exercise jurisdiction over parties who don't live there? And did the trial court, in that case Judge White, correctly interpret that law and apply it to the facts of this case? So that's what's called de novo review. Those are always the best legal issues to work with on appeal because the court is going to look at it independently. They don't have to give any deference to the interpretation that the trial court gave. They're certainly going to look at the trial court's justification, the cases that they cite, and so forth, but that's not going to be binding on their decision. That's very different from decisions that a judge makes that deal with the conduct of the proceedings, the conduct of the trial. And so that typically includes decisions like what type of evidence is admitted, whether the evidence is admissible under the rules, whether a party has engaged in conduct that's sanctionable. These types of things are a matter of court discretion. The rules, certainly, if the judge misinterprets, for example, a rule of admissibility and applies a standard that's incorrect, that indicates that the judge is not appropriately exercising its discretion. So that would potentially be reversible. But most of the time, that's not what evidentiary errors are dealing with. They're dealing with the trial court's judgment that, for example, some type of evidence is more prejudicial than probative, or that, for example, certain types of prior misconduct, there are often findings a court has to make that deal with whether this conduct probably even occurred. So these exercises of judgment are the type of examples of discretion that the court has in essentially determining how the trial is going to go forward. These types of decisions get an enormous amount of respect from the Court of Appeals because they don't want to be in the business of basically Monday morning quarterbacking the judge. Being a trial judge is not an easy job. They often have to make a lot of these decisions on the fly. They have context with the parties, the case, and just simply being present in the courtroom that the Court of Appeals doesn't have. Appeals are decided on the basis of the written filings that were filed in the trial court and the transcripts of the hearings. And there is a world of difference between reading a dry transcript of a trial or a hearing or something like that and being actually present there, seeing how the parties present, seeing their tones of voices. There can just be a big discrepancy between actually living it and reading it on a page. So the Court of Appeals is not going to assume that it has better judgment from its dry pages than the trial court had actually living through the experience. Appeals are a long process. Like I said, 30 days to file the notice of appeal. And then once that is done, there's a process of compiling the appellate record. And so that's what I was talking about when I said the appeal is decided on the basis of the court filings and the transcripts. Typically, a party appealing will need to order whatever documents they want set up to the Court of Appeals and whatever transcripts they want sent up to the Court of Appeals. Those have to be prepared, they have to be paid for, and they have to be transmitted. And so that can be a pretty time-consuming process. We did see that they had live transcription during the course of this trial, but typically live transcription is considered a rough draft. There's a lot of editing and checking and formatting that transcripts need to go through to be finalized for an appeal. So I would anticipate that that's going to take some time, and it's also going to cost some money to get that done. In my state, it's typically about 2 months from the time that I order those documents to the time that they're due to be filed. Often, if it's a lengthy process, like a 6-week trial, it's going to take longer than that. That's just the reality. The court reporter has other work to do. You just have limits on the amount of time you can put into a project like that. So it could potentially take more. It's not uncommon where I practice to see extensions of time granted for that purpose. After the record is perfected, meaning everything is sent up to the Court of Appeals, then she will have to file a brief. And so an appeal brief needs to identify what specific issues she is saying Judge Azcarate got this wrong, and as a result, I am entitled to a new trial. And she needs to provide her legal argument supporting those issues. So as I've said, typically she needs to identify an error of law or an abuse of discretion on a discretionary decision. But she also typically needs to show that because of that error, the outcome of the trial was affected. So this is why, by and large, I don't have real big concerns about whatever issues she may ultimately decide to raise in the appeal process. We saw on, the Today Show or CBS This Morning or whatever it was, that she mentioned some of the issues she expected to appeal were the trial court's ruling that the UK judgment did not preclude a trial in the United States as a matter of collateral estoppel. This is an issue that I already looked at substantially, did a lot of research into it back when it was being litigated. It is crystal clear that the law is not on Elaine's side, so although it's a legal issue that the court is going to look at independently, gotta say I don't see a lot of room for them to deviate from the ruling that Judge Azcarate reached. Quite frankly, given how Elaine argued that particular motion, taking a position that the law was something other than what anybody reading the law can plainly see that it is, I really thought she was deserving of sanctions for that particular motion. So if she repeats that in the Court of Appeals, frankly, I hope they're a lot less tolerant than Judge Azcarate was. The other thing that Elaine has mentioned in these programs was the exclusion of evidence. She has yammered on and on and on about medical records that got excluded and the text message from Stephen Deuters. These are hearsay, and so the burden is always on the proponent, meaning Elaine in this case, to establish an exception to the hearsay rule for that evidence to be admissible. Now, therapist notes are probably going to be a little bit different from a medical record. It may depend a little bit on what the therapist's qualifications are, what the nature of the therapy was, but we certainly heard just in the course of this trial that the role of a therapist is not to challenge the client, the patient. It's not to ascertain the truth of what they are reporting. It is merely to accept it at face value and offer support for it. And so that is likely to take it out of the realm of the traditional medical records exception to hearsay. That exception basically says that because you are incentivized to be honest with your doctor so that they can give you treatment and heal your problem, those types of statements are likely to be reliable, and therefore they justify being admitted in court even though they are technically hearsay, which is presumed to be unreliable in United States courts. The therapist records, to the extent that they are just there to document and support what is being said without any type of inquiry into truthfulness or justification, they simply don't satisfy that exception. But there was also an indication during the trial that some of Amber's evidence was excluded because it was not timely produced. They have deadlines for production of discovery, and if you don't meet those deadlines, then you have not complied with your discovery obligations and you can be sanctioned for that. And one of those sanctions is exclusion of evidence, which is very appropriate in a situation where the harm has been you've delayed it to the point that the other side doesn't have fair notice of it, hasn't had a reasonable opportunity to be able to contest it. So that's an example of the type of discretionary decision that I think is very unlikely to be overturned. Stephen Duder's text, I don't even know what the proffered exception to that would possibly be. Nobody called Stephen Duders as a witness, so it wasn't admissible for impeachment or, to otherwise just elicit it from him. So I don't know what the possible basis for that one is. She did try to get out on the stand this theory that it was actually Johnny Depp speaking through Stephen Duders, but it doesn't sound like there's really a basis for that. Judge Escarati shut down that testimony. So it basically sounds to me like they're just saying that they don't have any justification for it. And so that makes it very unlikely that the Court of Appeals is going to say, oh, well, Judge Escarati got that wrong for whatever reason. Once Amber Heard files her brief, then Johnny is going to have an opportunity to respond. So the order on appeal goes typically like the order in trial, except the appellant is the party who gets to go first. So they'll go first, Johnny will get a time to respond, and then Amber will have an opportunity to file a reply. This briefing as well, this can take a long time. So the deadlines that I typically work with in my court, once I get my record, I have about a month and a half to file a brief. The state will have 2 months to respond to me, and then I'll have a month to respond to them. So you basically have a 6-month period where you're just dealing with the briefing. So once they've received it, reviewed it, done their own research, argued it if necessary, then they have to decide it. And the deciding it is often a process all of its own. Appeals are typically decided by a panel of judges, not just one single judge. So there's a process of needing to reach consensus, not just on the outcome, but on the reasoning that leads to the outcome. And so what that means as a practical matter is that they may informally understand between them how they want the decision to come out. But one of the judges is going to have to write the decision, and then that's going to need to be circulated to the other judges, and they may disagree. They may not agree with some of the reasoning. They may not agree with some of the case law that's relied upon. And so there can be a process of revision and sort of negotiation in the course of finalizing the written decision before a majority of the judges will agree to sign off on it. Again, in my court, that process itself can take several months. So all in all, we're typically looking at, a year is fast for an appeal to be decided. 2 years is not at all out of the realm of possibility. And a lot of that can just depend on variables like what is the court's caseload. If they've got a lot of appeals, it just takes them longer to go through the ones that they have and get the decisions out. Factors like the length of the case can also matter. If they need to read 6 weeks worth of transcript and then, who knows what in terms of pretrial hearing transcripts and motions and things along those lines, that can take a significant amount of time as well. With an evidentiary issue like excluding hearsay, it's almost certain that the Court of Appeals is going to need to read the entire trial because, like I said, the key question is going to be even if this was error, did it really have any impact on the outcome? And the only way they can really evaluate that is by looking at what was the totality of the evidence here, what were the key issues in dispute, what can we ascertain from the jury's verdict, were the factors that had the most influence on them. So you're not going to do that by just cherry picking the parts that Elaine wants you to read. You're going to need to look at the entire trial to understand these alleged errors in context. So I've gone on a little bit longer than I intended to, but I just wanted to fully address those questions to the best of my ability. If you have others, please feel free to drop them in the comments and I will do my best to get to them. But that is what to expect from the appeal process. I have not seen anything so far in this case that leads me to believe that Amber has a particularly strong prospect on appeal. The only thing I haven't mentioned so far that I will is that Johnny does also have the right to appeal himself. He can appeal from the verdict on the second statement in Amber's counterclaim. He may have a little bit stronger grounds because there are more legal issues embedded in his claim concerning the agency of Adam Waldman, the scope of that agency, and whether there was sufficient evidence presented to the jury to substantiate a finding on those grounds. There was also the question that he raised during the jury instruction conference concerning whose actual malice are we actually looking at here? Does the jury need to find that Adam Waldman specifically acted with actual malice, or can it impute some actual malice from Johnny to Adam Waldman? That's a legal question. That is the type of thing that he could ask the Court of Appeals to look up. So I haven't done any research on that particular issue, but I did find it interesting when he brought it up. So that may be something that they would consider looking at as well. Hope you found this helpful. And like I said, if you have any questions, drop them in the comments and I will do my best to get to them. Thanks for watching.